This story coming in, it looks like more and more like these cases against Trump could be falling apart. Joining us now, former federal prosecutor Francey Hakes and former congressional investigator Sam Dewey. It's good to have you both on. Francey, first to you. The U.S. Supreme Court today, the majority sounded like they may limit special counsel Jack Smith's 2020 case against former President Trump about presidential immunity. What does this all mean now, Francey?
Well, you know, it's so interesting, Liz, because it did seem like a large majority of the court certainly thought that there has to be some presidential immunity for official acts. I think before this case was brought, these cases were brought against President Trump, most people assumed presidents had immunity for official acts like others do in Congress, like the speech and debate clause. But these cases are just extraordinary that have been brought against the president. And I think the arguments today suggested that President Trump will get a very strong ruling from a majority of the Supreme Court that at least his official acts are immune from criminal prosecution. The question then becomes which are official acts and which are personal acts.
Let's show the New York Times headline on it, because even the New York Times is saying it. So what do you think? Where do you come down on this, Sam?
I think that's right. I think that a court majority, probably either 5-4 or 6-3, is going to say official acts, core official acts at least, have immunity, and they're going to send the case back down to the lower court to make factual findings and say, under this test, what was an official act. Bottom line, that would push the case beyond the election. So that's where I think it's going to go. I also think the argument was just extraordinary that we have reached that point. We were having that argument in that setting and having to discuss liability for core presidential acts.
Okay, so let's listen to former President Trump. He spoke today about how the Supreme Court hearing was a game changer. Watch this.
But the U.S. Supreme Court had a monumental hearing on immunity, and the immunity having to do with presidential immunity. And I think it was made clear, I hope it was made clear, that a president has to have immunity, or you don't have a president, or at most you can say it would be a ceremonial president. That's not what the founders had in mind.
So, Francey, what's your reaction to that? By the way, former President Trump got a big outpouring of support from New York City construction workers. Let's show that. What do you think of what he just said?
Well, you know, in my opinion, Liz, I think the most extraordinary thing today was that some of the justices seemed to take it as a given that the Department of Justice, prosecutors, and grand juries could be trusted to be politically neutral when it comes to prosecuting someone like a former president of the United States. And I think that if you just look around the country, here in Atlanta, you looked in Florida, in New York, and in D.C., I don't see why any of the justices of the Supreme Court should be comfortable that you've got neutral prosecutors. Certainly the New York case shows very clearly you don't. There's not even a crime there. And I think the justices of the Supreme Court should really slap that down, and they should not be taken as a given that these entities are not political.
You know, the Supreme Court did appear open to a middle ground on presidential immunity. Sam, that's what we heard today. What do you think? What does that mean, a middle ground?
I think the middle ground is to say that core official acts are immune, and then to send it back for a finding on what is an official act. There was reference to Blazingate and an opinion by Judge Castis, and that may be the rubric they used. I just want to detail, though, on what Fanny said. The extraordinary nature of this case isn't just in the reliance on the jury. It was also the Department of Justice position. Michael Dreeben is a great lawyer, but he was pressed, and he said, well, yeah, obviously there's immunity for a core act like appointments. And then he was asked, well, wait a second. That was charged. And he had to say, well, yeah, this case is different. This is the one case that is different. And I think that gave away the game. The Department of Justice is attempting to create a regime to fit one man, President Trump.
Okay, so the way it seems to be breaking down, the liberal justice is skeptical of absolute immunity, the conservative justice moving the other way. You know, we're talking Justices Neil Gorsuch, Samuel Alito, Brett Kavanaugh, Clarence Thomas, Chief Justice John Roberts. He appeared to be looking for an off-ramp to send the case back down to the trial court. That will delay it past the election. Let's take a listen to what the justices said. Watch.
If an incumbent who loses a very close, hotly contested election knows that a real possibility after leaving office is not that the president is going to be able to go off into a peaceful retirement, but that the president may be criminally prosecuted by a bitter political opponent, will that not lead us into a cycle that destabilizes the functioning of our country as a democracy? So what about President Franklin D. Roosevelt's decision to intern Japanese Americans during World War II? Couldn't that have been charged under 18 U.S.C. 241, conspiracy against civil rights?
It seems to me there is some area you concede that an official acts that Congress cannot criminalize, and now we're just talking about the scope.
Francey, take on what you just heard.
Well, I agree with the justices there, and that is what happened during the argument. I think it was rather extraordinary that you had Michael Dreeben had to concede that there are some cases where the president has immunity. I think in this case, though, what's going to happen is it will get sent back down to the judge. The judge is going to have fact findings. That means witnesses and hearings, make a decision, and it'll go right back up to the Supreme Court again, where there'll be lots of disputes and more oral argument. This isn't going to trial anytime soon.
Got it. Sam, wrap this up for us.
I think that's exactly right. This isn't going to trial anytime soon, and stay tuned for more law that's made just for Trump. And one final concession at the argument that's important. Dreeben conceded the Solicitor General was consulted and opined on the position. That means the highest levels of Biden's Justice Department, not the special counsel, weighed in to go after President Trump.
So what does that mean?
It means that Jack Smith is not he is the special counsel, but the notion the White House isn't involved, that the president's political appointees aren't involved, that's not correct.
So
they were involved.
So it's not independent. Francey Hakes, Sam Dewey, thank you so much. Good to see you.